Our next case of the morning is agenda number 12126-577, Jane Doe versus Bo Parrillo. Are council ready to proceed?
Yes, Your Honor. Yes, Your Honor.
Mr. Volker?
Yes, Your Honor. Good morning, Your Honors. May it please the court, counsel. My name is Daniel J. Velker, and I am the attorney for the plaintiff in this case, Jane Doe, also the appellant. First of all, I wanted to thank you for accepting our petition for leave to appeal. We greatly appreciate that. I know you're a very busy court. I think that this case presents an issue which is of extreme importance, not only to my client, but to the citizens of the state of Illinois. In particular, this case involves the award of punitive damages and to what extent punitive damages can be reduced or remitted, so to speak, by the appellate court and under what circumstances. But we have background. I'm sure this court's fully aware. The concept of punitive damages has been in existence in this state and has been written about by this court for over 175 years. The court has, for almost a century, recognized that once actual damages are established, that the jury is accorded great latitude in awarding punitive damages. The purpose of punitive damages is not to compensate the victim or the plaintiff. On the contrary, the purpose of punitive damages, as Your Honors I'm sure are all aware, is to punish the defendant and to deter the defendant as well as members of the community from engaging in such egregious or willful and wanton misconduct in the future. The concept of punitive damages is to send a message to the community regarding what conduct will and will not be acceptable in the community. Importantly, this court has held that there's no requirement, and this is a key issue, this court's found that there's no requirement that the amount of punitive damages bear any relationship from a proportionality standpoint to the amount of the compensatory damages that are awarded. In fact, that case is Deal versus Byford, which also stated the concept, which is also very important, is that an appellate court will not reverse an award of punitive damages unless there is some evidence that there was some passion, some prejudice, or some corruption in the jury process. Importantly, in this case, the court, in its appellate decision, as well as the circuit court, didn't reference or identify a single scintilla of evidence that would go to the issue or would support a finding of passion, prejudice, or corruption. In International Union of Operating Engineers, Local 150, decided in 2006, this court, for example, approved a punitive damage award that had a multiplier of 11 times the compensatory damage award, and did not find in that case that a multiple of 11 was unconstitutionally excessive. Under the long-standing decisions of this court, a reviewing court will not disturb an award of punitive damages on grounds that an amount is excessive unless they find passion, prejudice, or corruption, or that they find the amount of the award exceeds constitutional limitations. The United States Supreme Court, as I'm sure the court's aware as well, has spoken in BMW versus Gore and in State Farm versus Campbell on the issue of what is constitutionally acceptable. And in those two cases, the U.S. Supreme Court found that under the Due Process Clause in the United States Constitution, an award of a single-digit multiplier is constitutionally permissive. Of course, a single-digit multiplier would be a multiple of 9, up to 9.99, let's say, of the compensatory damage award.
Very clearly, the message from the United States Supreme Court is there are limits, but how to determine that limits is a little hazy. The language the court continues to use is the keystone is reasonableness, and a reviewing court should be looking at the grant of punitive damages and whether or not they in fact are constitutionally firm about whether they're reasonable. And certainly courts have struggled with just what does reasonable mean. My favorite quote, if I just could share, from the United States Supreme Court in TXO Products Corp. says, the guidepost can be shorthanded as reasonableness with the caveat that larger multipliers might start to, quote, raise a suspicious judicial eyebrow. Whatever that message from the Supreme Court is, it's a little unclear. So when we're talking about reasonableness, what factors should we look at?
Well, Your Honor, that's a very good point you raise, and I would agree with you. There is some ambiguity in the Supreme Court's decisions, notwithstanding the fact that they have permitted and they have stated that single-digit multipliers are acceptable and not a violation of due process. But I think the most important factor identified by the Supreme Court in their cases is the severity of the conduct on the part of the defendant. So where the Supreme Court has stated in the past, the Illinois Supreme Court, that you have to find passion, prejudice, or corruption in order to disturb a punitive damage award. Obviously, the exception to that rule is if it exceeds constitutional limitations, which is what you're raising. And the issue there, if it doesn't exceed constitutional limitations, is whether the award, I suppose one could argue, is reasonable in light of the severity of the conduct. So to some extent, in this case, the severity of the conduct is so grave, so egregious, that I would argue that an award of punitive damages up to the limits provided by the United States Constitution, Illinois State Constitution, Due Process Clause, would be acceptable, and that the appellate court simply has no authority under your decisions to attempt to reduce or reverse that award. In this case, Your Honor, the appellate court specifically found that the conduct of the defendant was severe. The court actually said, while not undermining essentially the severity of the defendant's conduct, we think $1 million is adequate for purposes of punishment and deterrence. On the contrary, respectfully, it was up to the jury to decide what was necessary to send a message to the community, as long as it is within the bounds of what's acceptable from a constitutional limitation. I mean, this was a case of, as your honors are aware, sexual assault, something that the judge of 24 years identified as rape in his decision. He heard the evidence, as well as the jury. So as a consequence, you're right, there is no bright line test, Your Honor, but that's part of the problem, I suppose. In this case, the appellate court found a bright line test. They basically found that their decision in Blount established essentially a bright line test in this state. Notwithstanding this court's decisions that there is no bright line test, they found there's a bright line test, and they said that test is a multiplier of approximately 4x, or 4 times the amount of the compensatory damages award.
Is that what Blount said?
I'm sorry, Your Honor?
Is that what Blount said?
That's how they interpreted Blount. I read Blount again this morning.
Right.
I'm not sure I read that.
Blount quoted the United States Supreme Court in Haslip, in which Haslip said that trying to decide what this reasonableness is, the standard is what it means in terms of constitutional infirmity, that the court said that even though a punitive damages award of more than 4 times the amount of the compensatory damages might be close to the line, in that case, it did not cross the line into the area of constitutional impropriety. And that's what Blount did, was quote a case from the United States Supreme Court.
Yes, yes.
Which does not make literally does not draw a line.
That's correct, Your Honor. And Blount actually is a case involving retaliation, discrimination. I think, as I recall the facts, it involved a woman who had been discriminated against and retaliated against, so she claimed, because she'd refused to perjure herself in connection with some kind of a proceeding. And I would suggest to you that that is not necessarily as severe a conduct on the part of the defendant as what we face in this case.
Counsel,
Yes.
In determining reasonableness, would it be appropriate to compare the case to other similar conduct, cases involving that? And therefore, are there any other cases out there that would be similar or comparable for analysis purposes?
Not that I've found, Your Honor, certainly not from this court, I don't believe. And I think, of course, it would be reasonable to do that. But the problem that I think we have there is that we start to run up against the long-standing precedence of this court. Since 1921, this court has said that the juries awarded great latitude. It's up to them to decide what is to be morally condemned and what is not. The courts have also said that the issue of compensatory damages is a factual determination, and therefore you have to apply principles and rules and mathematics. But on the other hand, punitive damages are simply an expression of moral condemnation of the kind of conduct that's being engaged in. And I would suggest that this conduct is the most egregious short of murder. And with that in mind, I think that this plaintiff was entitled to an award from the jury, which bumped up against the due process limitations.
Should we at all consider whether the facts in this case, as I understand them, that there really was no defense to the case, the defendant didn't appear and didn't present any evidence? Should that in any way inform or have any effect on the decision of the court as to whether the award is reasonable?
In all due respect, Your Honor, absolutely not. And the reason why is because I don't think punitive damages are a reflection of the quality of the defendant's representation. It certainly reflects the defendant, in this case it's a he, his conduct. The fact that his lawyers abandoned him at trial, the fact that he lied about his whereabouts and chose not to attend the trial, I don't think that should be taken into account. That's the result. Whether the jury took that into consideration or not, that he wasn't there, we'll never know. But that's the predicament that he created for himself. That doesn't have any impact on the fact that the testimony was what it was, and he had every opportunity to contradict that testimony. And he ignored that opportunity, and he waived all of his defenses. Both he and his lawyers waived all those defenses. So we're left with the record that we have, because that's the. Yes,
they did monitor the case though outside, didn't they?
Well, they peeped in the glass window. They couldn't hear what was happening, Your Honor, unless they had some kind of a eavesdropping device, and they were just looking through the window. They were there from time to time. And I'm happy to get into that if the court would like to hear it, but I'm sure counsel spent quite a bit of time on that, his response.
In light of the previous question about comparing, this court, the trial court, the appellate court seemed to think this shocked the conscience, this award. There's an appellate court opinion in our state, France, that went through three elements: the degree of how reprehensible the defendant's conduct was, that's number one. Two, the disparity between the harm suffered by the plaintiff and the punitive damage award. And three, the difference between punitive damages awarded by the jury and the civil penalties authorized or opposed in comparable cases, as Justice Garman was talking about in comparable cases. What do you think about those factors?
Well, I certainly agree with reprehensibility of the conduct, severity of the conduct. That's a long-standing concept, been around for a long time. I'm sure I understand the civil penalty aspect of it. I think the defendant tried to argue in their brief that somebody who was convicted of a crime like this would only spend so much time in jail or have to pay so much of a fine. I don't really think that has anything to do with the moral condemnation of your peers. In this case, was decided by 12 jurors, 6 men and 6 women, and I don't think it shocked their conscience. I think what shocked their conscience is what this gentleman did to her. That's what shocked their conscience, and that's why they awarded what they did. The appellate court
a moment ago, you said something about, this is the record we have. Well, we don't have a record. We don't know what the testimony was. We don't have a transcript. Certainly most of these cases, when they do their analysis, they look specifically at the testimony that was presented to the jury. We don't know. So what tools do you think we should use to try to understand how all of these factors play into the determination of reasonableness when we have no transcript of the trial itself?
Well, Your Honor, that's a good point. What obviously this court has said, as the appellate courts have all said, it's the burden of the appealing party to create the record if they want to appeal a decision. And they didn't do that. They decided not to do that. It was not foisted upon them. They did that deliberately. So that problem is theirs. But in response to your question, Your Honor, a very good question, I would say what we have is we have the decision of the jury, number one. Number two, we have the behavior of the defendant by lying about his whereabouts, not attending trial, not being unwilling to defend himself and being willing to lie to the circuit court to try to obtain a continuance. We have the fact that his lawyers apparently had nothing to say because they abandoned the case and walked out of the courtroom and ran and hid in the hallway. Abominable as that might be, that's what happened. We also have the judge's comments, Your Honor, the circuit judge's comments after the trial, who said this was the most egregious, these aren't his exact words, but he said this is the most egregious example of gamesmanship I've ever seen in 24 years of being a trial judge. And we also have his statement in his decisions that what he observed was a rape, was a sexual assault on a young lady, a young woman. So frankly, we have photographs in the record, Your Honor, of a battered young woman, right? We have a Northwestern hospital admittance form for her admittance to the hospital to treat her injuries. We have text messages from the defendant where basically he says to her, if you stop seeing me, you will be looking over your shoulder for the rest of your life. And you know what's going to happen to you essentially at some point when you're not looking over your shoulder. So that to me is a pretty big modicum of evidence that supports the shocking of the consciousness that the jury obviously felt about what this gentleman had done. And then his failure to appear perhaps at trial to defend himself. His defenses, Your Honor, that the defendant mentions in his brief, is that he was provoked. Provocation. I don't understand how anybody can be provoked to rape a woman. That's literally impossible.
The common law
yes,
record
sir.
also contains the complaint upon which the jury reached a verdict, correct?
That's correct. It does, Your Honor. So we have that as well.
Are there jury instructions?
There were jury instructions.
And that's in the record?
There were jury instructions.
They'd be there.
And we had a couple of jury instruction conference, which the defendant's counsel chose not to attend.
And of course, we don't have a record of anything about the.
Well, the jury instructions are in the record. The jury
We
instructions.
have the actual instructions.
Absolutely, Your Honor, we do. We do. And I think I want to make a point, too, before I run out of time here, is that even if the appellate court was correct that there is a bright line test now in the state that perhaps this court wasn't aware of, but they are, that's 4X, a multiplier of 4X, that they didn't apply that multiple. They said in their decision that this case exceeds constitutional limitations, that it bumps up against constitutional ceiling, but yet they awarded her only $1 million, which is, I would argue, is arbitrary and capricious. The appellate court simply can't decide where to come out on damages just because they say, all they said in their decision was that in their view, this is enough to punish the defendant and deter him from such misconduct in the future. Respectfully, how would the court know that's enough? They didn't hear the evidence. The jury heard the evidence, and I think the jury's verdict should be held inviolate. I think the jury's entitled to, after spending their time and reviewing the jury instructions and reaching a unanimous verdict, that original verdict of $9 million, eight of which are punitive damages, should be sustained. And I think that's why we're asking this court, respectfully again, to reverse the decision of the appellate court and to reinstate the original jury verdict, which was $1 million in compensatory and $8 million in punitive damages, for a total of $9 million. Thank you, Your Honor.
Is the fact that they chose not to show up at the trial itself, not to participate in the trial, to remain silent at the trial, is that a evidentiary factor also?
No explanation was ever given to the jury as to why they weren't there, but they weren't there. So it's pure speculation, but I would suspect that, one can perhaps,
I'm not talking about speculation.
Okay.
Just the fact, we know as a fact.
Okay.
They did not participate in the trial. And from the record, it appears that they voluntarily chose not to appear at the trial.
Correct.
The defendant's attorneys. Is that a substantive fact that can be considered as an evidentiary fact in this case?
I don't think
remaining silent.
I don't think it can, Your Honor. I don't think it needs to be. I think the fact remains that by not appearing, they didn't present any evidence. They didn't present any contradictory evidence. So the jury, just common sense, the jury would be more likely to believe you if they don't hear the other side, right? Now, one could argue that had the defendant appeared, they would have entered a verdict of more punitive damage, a larger award, after hearing him and seeing him testify and thinking he was lying on the witness stand or committing perjury of some sorts regarding what had actually happened to this young woman. But I don't think technically it is really an element of the consideration of the propriety of the punitive damage award. Thank you, Your Honors.
Thank you, counsel.
May I proceed?
Yes, you may remove your mask if you wish, sir.
Thank you. Good morning, everyone. My name is Ronald F. Neville, and I represent Bo Parrillo, the defendant in this case. We're asking this court to reverse this case and send it back for a new trial. Why are we asking that? Because the circumstances were we had a jury trial, defendant and the defense counsel were not present.
Well, why weren't they present?
A series of circumstances occurred.
From the record.
An emergency motion for a continuance was filed the evening before the trial date. The motion was to be presented at 11 o'clock in the morning the following day, the trial day. In Cook County, the assignments for trial are made at 10 o'clock. The emergency motions are heard at 11 o'clock. Allison Muth, who was the defense attorney, included in her emergency motion that she was a caregiver for her mother who had serious pulmonary disease, emphysema, and was having difficulty breathing, and she was the only available caretaker for her. And therefore, she was looking for some time to continue the trial so she could assist her mother. This was a question of the mother dying. This was a breathing issue that she had to help her with. The motion was filed. Allison Muth, that very morning, the 14th of January of 2019, was caring for her mother. And as a result, she didn't get to the courtroom till 10:15. The case was already been assigned to Judge Varga in the law division. She went to the courtroom to explain what happened. Judge Varga refused to rule on the emergency motion, not because he didn't think it had any merit, but because he didn't think he had any authority. He said that Judge Flanagan, the presiding judge of the law division, was the only person who could rule on the motion. That is grossly incorrect. He's a full circuit judge. He has every bit of authority to rule on a motion that's before him if justice requires. And Judge Flanagan's standing order even says, essentially, that any judge can make a ruling that he deems appropriate despite the standing order. He then he actually went down to see if he could talk to Judge Flanagan, but couldn't find him. And then he found out the motion had been rejected by the clerk. Came back up and he recessed till 1:30 in the afternoon. Ms. Muth goes to the clerk and finds out it had been rejected electronically because she had marked a box that said confidential. She was talking about medical issues, and I think that's what was in her mind. That was rejected for that reason because there has to be an order allowing confidentiality to be checked. She then went and prepared a second motion. The morning she was going to court, the day of the trial that was scheduled, she learns that Bo Parrillo's father is in Florida, who is unexpectedly now, no one expected, is in danger of death from a heart disease. He was ultimately 2 days later airlifted by air ambulance to Chicago to get treated. He's lucky he's alive today. And the defendant wanted to be with his father, who he thought he was going to lose.
So
that was
let's can I talk about that for a minute? So at some point, and I'm not sure when, that's why I'd like to ask you this, there was an affidavit attached to this motion for a continuance of trial. This is a case that's been pending for years, and now the court has said you're going to trial. So the day of trial, all of this comes out. Somewhere along the line, the attorney files a motion for continuance. It contains an affidavit from the defendant himself, saying that he was unavailable to be present at trial because he was in Florida.
That's true, Judge.
Was that true? Was that a true or a lie?
It was incorrect. He did not go to Florida.
So he filed an affidavit saying, I'm in Florida, and it was incorrect, that he was not in Florida.
Well, Judge, let me explain the circumstances. He was intending to go to Florida, and the record has the airline tickets for him to go to Florida because he wanted to be with his father. In discussions with the medical people in Florida, they were considering what they ultimately did, and is that return him by air ambulance to Chicago. There's a second affidavit in the record where he explains all that, and that he was very upset about his dad. He didn't think things through clearly, but he didn't think his location was the issue. He thought the serious illness of his father was the issue.
I'm sure he felt concern about his father's health. Was anyone concerned about filing an untruthful affidavit with the court?
Well, I don't think that was the mentality. I'm going to lie to the court and gain an advantage. That's not what happened here. He simply had an affidavit signed that included a fact that wasn't true, that he didn't consciously think mattered. He didn't say to himself, I'm going to lie now.
So you're going, and maybe we need to talk about the legal issues here rather than the factual issues. But I need,
Judge, I don't
know at which one of the motions for continuance on the day of trial, and then it was put off the next day. The lawyer was trying to file a motion for continuance. She attached this affidavit that was untrue.
No, that's not
How
what.
did the affidavit?
That's not what happened,
That's my
Judge.
question.
That's not what happened.
How did the affidavit that was untrue get in the record?
The motion itself was a 101-109 attestation. The affidavit that was filed, I'm not positive exactly when it was filed, but the motion itself said that it was based on the father being seriously ill. The affidavit you're talking about is in the record, and there's a second affidavit explaining the details of it.
But you're not sure at what point that got in the record?
Not as I stand here.
Thank you.
When the motion was denied,
Hold on, Judge.
when the matter was going to trial,
Yes.
okay, and the lawyers for the defendant chose not to be in the courtroom.
That's just not true, Judge. That's not, that they didn't choose to be in the courtroom. Allison Muth was trying to get the motion ruled on. She was in another courtroom. There was a second lawyer whose name is Robert Holstein. She had asked him to be kind of a second chair with him. He had never met the defendant, only had a surface knowledge of the facts of the case. He couldn't possibly defend the defendant. He didn't know anything about the case in those terms. He wouldn't know how to, he's never talked to...
The lawyer who knew about the case, who was in another courtroom.
She was in another courtroom.
Okay. Well, was she in the other courtroom all day?
She came to the courtroom on, the trial day was January 14th. She comes to they knocked it over to the next day. On the 15th, she was with her mother. She gets to court late again because she's dealing with her mother. She got there approximately 11:15, 11:30. She tried to get the presiding judge to rule on the motion, but was told to come back the next day and he would hear it. She then went to the chief judge's courtroom, Judge Evans, to see if she could get some relief there, but Judge Evans was not available. It's then when she went back to the courtroom, the plaintiff was, they'd already picked a jury, they had already made their opening arguments, the plaintiff was already testifying, there was nothing else she could do. She went to her office and she prepared a motion for mistrial because she wasn't allowed to present her defense.
Was the door barred?
I'm sorry?
Did they bar her from entering the courtroom?
I'm sorry, Judge.
Did they bar her from entering the courtroom?
When she arrived after she had been a chief judge, she came in and sat down. No, she left to go do her motion. When she came back, they were having an instruction conference, and they wouldn't let her be involved in that. There's a disagreement as to whether she was being allowed to engage in a but the case, it was all over. She got the testimony was all over by the time she got back. There was no abandonment of the trial. There was a sincere attempt on her part to get a ruling on her continuance motion.
Is it absolutely clear that she wasn't allowed to participate?
Well, she wasn't there. See, what happened here is a judge...
Talking about with the jury instructions.
With the jury trial, for no reason, the trial judge started a jury trial. He didn't even know where she was. He didn't know whether there had been a ruling on the motion for a continuance. He didn't know anything except it was 9:45 and he's going to start a jury trial. That's what happened here.
He continued the case for 1 day.
He did.
Okay. So he said, I'm giving you a day to do what you can about motion for continuance. We're starting the trial tomorrow. And he did.
Well, he did, but he shouldn't have, with all due respect, because what resulted here is you ended up with a jury trial, no defense. So we're talking about punitive damages and what's reasonable. What would be reasonable is to understand what the conduct was. And the conduct has to be tested through cross-examination, through impeachment, through opening statements, through motions in limine. None of that was allowed here. Judge Vargo could have ruled on the motion, and he should have ruled on the motion. His belief that he couldn't rule on the motion in and of itself is an abuse of discretion. Any judge who has an incorrect view of his or her powers...
we should talk about legal issues here. Right? The motion asked for a 30 to 60-day continuance.
Well,
he granted the motion, and he said, I'll give you 1 day.
No.
So...
I'm sorry, I did not mean to interrupt you.
No, go ahead. Are there legal
You're correct.
Are there legal issues we should be discussing here?
You're correct that the motion talks about 30 to 60 days, but one thing I want to make a point here, the plaintiff has never contested the statement of facts in our brief. Never. There's no contest on that except about an issue about a jury instruction conference, excuse me. I lost my train of thought there, I apologize. The fact of the matter is that her affidavit, Allison's Booth affidavit, which is part of the record, was asking for a couple of days. And all Judge Varga had to do is one more day. One more day, she could have got a ruling by the presiding judge, and if he denied it, then she'd have to go to trial. If he granted it, he would have some time. We believe there's an abuse of discretion here, in that when a defense attorney is not there and you don't know why, you should at least find out. And she was out there trying to do a job by getting a ruling on a continuance on a very important matter.
So if a trial set for trial.
It was set for trial.
And somebody doesn't show up, you're saying the burden is on the trial court to start making inquiries why the person's not there? I
do when he knows there's a pending motion for an emergency motion for a mistrial, a pending motion for a continuance, when he knows that the defense attorney's mother is seriously ill and she's trying to care for him, when he knows that the defendant's father is critically ill in Florida and that's why he's not there? Yes, I think he has a duty.
How many medical affidavits were attached to these motions?
There were all the medical records. There was a letter from a doctor. So there weren't affidavits, but there was the affidavit of the mother with the medical records attached. There was an affidavit of the father with the medical records attached at the post-trial motions. We included all that
In the
information.
post-trial motions?
Yes.
Yeah, but in the motions,
It just happened, Judge. I mean, it happened the same day. It wasn't possible at that point to go get affidavits to attach to an emergency motion for a new trial. She just learned that the very day of trial about the father.
how old was this case when it finally went to trial?
Well, it was 2019. I think it's a 2015 case. I think it's... But that really doesn't have anything to do with anything because no one expected the father's problem, and Allison Muth, the defense attorney, didn't expect this issue with her mother. And there's a case called Ullman where the court specifically held, appellate court specifically held, that if an attorney's wife, in that case the wife, so family member is ill, that's grounds for a continuance. It's never been distinguished by the plaintiff, and it stands as good law. It should have been followed. I'm losing track of my time here, Judge, and I do want to answer all your questions, but basically we had a jury trial here that we have no defense, no defendant, no opening statement, no cross-examination, no impeachment. But we also have to know that the jury was instructed with an issues instruction that constituted reversible error in and of itself. They instructed the jury with an IPI criminal instruction that has no relationship to what the civil issues were, says nothing about proximate cause. We'd ask that you take that into consideration when you're deciding what was right and what was wrong in this particular case. There's no question they were an issue on the pleadings. There's no issue that there was not an issue of fact that should have been resolved by a jury. I've explained to you the mishaps that occurred with defense counsel, the serious illness of a father and a mother. You've asked me what I think the judge should have done. The judge should have waited before he started that jury trial to at least determine the status of the ruling on the motion and find out where Allison Muth was, who, by the way, was trying to communicate with the court. They called, nobody answered the phone. She tried to get through with the Cook County telephone system. That didn't work. And keep in mind that this other attorney that was there, he couldn't defend this case. I'm not saying he was an incompetent lawyer. I'm saying he was incompetent for this case because he didn't know anything about it other than surface facts. He never talked to the defendant.
Counsel, can I ask you one question on the
Certainly.
punitive damage award? Has any court, either the trial court or the appellate court or any court, determined that this punitive damage award was the result of passion, partiality, or corruption?
In this case,
In this case.
no, the appellate court did not say that, but when you think about it, Judge, when a jury has doesn't hear a defense, doesn't have a plaintiff who's cross-examination, that's where the passion and prejudice comes in. So you hear one side, you hear a woman on a stand who says she's been raped. Their passions are aroused by that. Their prejudices are aroused by that. And when they don't hear a defense, when the credibility of the plaintiff is not tested, that's passion and prejudice in my view. That's part of the error in this case. And when you talked about the reasonableness of punitive damages, State Farm versus Campbell specifically said that if the compensatory damages are substantial, and I don't think anyone would disagree that $1 million in compensatory damages is substantial, then the ratio should be 1 to 1. And that's what happened here. The appellate court reduced it to 1.1.
Campbell dictates 1 to 1?
It says, that's not exactly what it says, but it says that where the compensatory damages are substantial, the constitutionality of punitive damages should be closer to being equal to the compensatory damages.
Thank you, counsel. Your time has expired.
Thank you.
May I proceed, Your Honor?
Yes,
Thank
please.
you.
Thank you.
So I want to respond to counsel's last point, and that was in response to the judge's question about was there passion, partiality, and corruption based on the fact that the defendant chose not to appear in court and defend himself and lied about his whereabouts to the circuit court. I would suggest that's not passion, corruption, or prejudice. That's merely abandoning your right to defend yourself. In fact, if that were the law that this court decided to impose, I respectfully suggest that it would give defendants who had committed egregious acts an easy way out by simply lying about their whereabouts and not appearing in court, and then any punitive damage award could be attacked on the grounds it was based on corruption, bias, and prejudice. I just don't think that's the intention of those three words. I think they're intended for something entirely different. They're intended when a jury's paid off, or when a jury is composed of the wrong, perhaps racial makeup, for example, or it's determined that somebody had a bias going into the case. And that makes sense, that an award should be impacted if that is the case. That's not the case here. Neither the circuit court nor the appellate court identified even a scintilla of evidence in support of that. Their decision to reduce the damage award in this case was entirely upon their new bright line test and their blount, that 4x is the multiple, the maximum in this state for an award of punitive damages in relation to the award of compensatory damages. And I suggest that conflicts, and it actually is completely opposite what this court has said over the last 175 years. I do want to address just for the record, because I think that as an officer of the court, this court, counsel made the statement that Allison Muth was prohibited from attending a jury instruction conference. That's a lie. And let me just say one thing. When Allison Muth came busting into the courtroom with her motion for mistrial, when the case was over and the jury was in the deliberation room deliberating, the judge, Judge Varga, who had bent over backwards to give this individual a fair trial and his lawyers an opportunity to defend their client, was simply collating the jury instructions and providing a copy to the bailiff so the bailiff could give jury instructions to the jurors that didn't have the IPI numbers on the bottom left-hand corner. There was no jury instruction conference going on at that point in time. So to the extent her affidavit states what was happening in that courtroom before she came busting in, I would suggest to you that she has no foundation to testify to that. How could she possibly know what was occurring in a courtroom that she wasn't in? I was there, and that's what was going on. And I stand by that as an officer of the court. I don't want to delve too much into what happened during the trial. I think the record's pretty straightforward on that. At the end of the day here, you've got a defendant who chose to lie to the court and basically just refused to defend himself. He had 2 days to clean up his act, so to speak, and get down to the Cook County Courthouse and defend himself. He refused to do that. You've got 2 attorneys that have a combined experience of probably 60 or 70 years of professional experience in litigation, who both voluntarily chose not to defend Mr. Parrillo. The gentleman attorney for Mr. Parrillo, judge asked him very, very kindly, don't you want to sit at counsel table and defend your client? And he said no, and he walked out of the courtroom. But
Had he filed an appearance?
He did file an appearance. Appearance was filed. I don't know who filed it, but an appearance
His
was
name
filed.
was-
That's my understanding.
His
Your Honor,
counsel in the case.
Yes. And he was given the opportunity to defend his client. He said, no, thank you. But yet, as the court acknowledged in the decision, not only was this the most egregious example of gamesmanship he'd ever seen in 24 years of being a trial judge in Cook County, which is a pretty powerful statement in and of itself, he also said that he also corroborated the fact that counsels were outside the courtroom during the course of this day-long trial, peering in through the glass, apparently waiting for the jury to go back and begin deliberations before Ms. Muth came busting into the courtroom with the doors wide open, asking for the judge to grant her motion for mistrial, which nobody had seen at that point in time. So in response to the argument that somehow that bears, that the defendant's entitled to a new trial in this case, I suggest that would be a whole travesty of justice. This gentleman's had his chance to defend himself, and he decided voluntarily not to do so. So again, we would ask this court to, unless it's going to adopt if it does decide to essentially adopt the bright line test of Blount, as the appellate court stated, that at a minimum, it simply reinstated at least an award for punitive damages at the $4 million level, which is what the appellate court says Blount says. So if you find, it seems sensible to me that if you find that $4 million is the ceiling on punitive damages, that if this passes that, it goes above that limit, that you would reduce it just to $4 million, not to $1 million. The decision to reduce it to $1 million, in our view at least, Your Honors, in all due respect, is just simply arbitrary and capricious. And it's better to let the jury decide what supports moral condemnation. It's better to let the jury decide what needs to be awarded to send a strong message to the community that this kind of terrible conduct will not be tolerated than it is to have the appellate court essentially substitute its judgment for that of the jury in this case. That's all I have.
Thank you.
Thank you, Your Honors.
Case number 126577, Jane Doe versus Bo Parrillo, our agenda number 12, will be taken under advisement. Mr. Volker, Mr. Neville, thank you for your arguments today. You are excused at this time.